All right, good afternoon, everyone. My name is Philip Mellon. I'm a staff attorney here at Homeline. Today we're joined by Julia Zwak, the managing attorney of the Minneapolis Housing Unit at Mid-Minnesota Legal Aid, and Courtney Arthur, the assistant supervising attorney of the Housing Discrimination Law Project, again at Mid-Minnesota Legal Aid. And today we'll be talking about disability rights in housing. So some quick housekeeping notes before we get going here. So what is Homeline? So we're a legal nonprofit that provides legal advice to tenants across the state of Minnesota, and you can reach us by phone or by email. We offer our services in 4 languages, English, Spanish, Somali, and Hmong. And you can see the phone numbers for each one there. Or you can find our email address at homelinemn.org/email. As some brief housekeeping notes, this session is being recorded, and we will have it on our website, homelinemn.org, in a few days if you'd like to review it. If you have any questions, you should have sort of 2 buttons at the bottom of your screen, one for chat and one for Q&A. We ask that you submit your questions through the Q&A because they're sort of easier to track on our end. However, if you use the chat on accident, not a big deal. We'll get to your question just after we do the Q&A ones first. If you're an attorney looking for CLE credits, we are applying for 1.5 standard CLE credits for this session, and we will have that code once it gets approved. So we will go ahead. Julia is waiting on Courtney to sort of figure out the Zoom here, but if she's ready to go, we can get going here.
We are ready to go.
All right, perfect.
All right. Thank you for the introduction and for inviting us to be here. We are grateful to talk about disability rights in housing. It's one of the top priority cases that we often see. A number of our clients are facing a disability, whether that's the central issue of their case or even just a tangential problem that they have to address in the context of their housing issue. So hopefully through this presentation, you'll learn something new. A lot of this might be overview for attorneys in the room, but if there are any tenants who are trying to learn more about your rights, I hope you can learn how to assert those. So as Philip said, my name is Julia Zwak. I'm the managing attorney of our housing unit at the Minneapolis office of Mid-Minnesota Legal Aid. Courtney and I are presenting from the same space here.
Hi, I'm Courtney Arthur. I'm an assistant supervising attorney with our housing unit at Mid-Minnesota Legal Aid. Thanks for bearing with me, having some technical troubles, but I think we'll get it done without too many issues.
So we'll just take turns. I'm going to start with some slides about MMLA. So next slide. So as an overview of what we're planning to talk about, first I'll share about our office, then talk about the main laws relating to disability rights in housing. Then we'll shift gears and talk about reasonable accommodations and modifications, including reasonable accommodations as a defense to eviction. Then conclude with talking about service and emotional support animals and options for enforcing any of those rights. Next slide. So Mid-Minnesota Legal Aid is an organization that provides civil legal services to people with low incomes in central Minnesota. We have offices in Minneapolis, St. Cloud, and Willmar, out west a bit. Our attorneys serve clients on a broad range of issues in the civil sector, including immigration, disability discrimination, public benefits, tax issues, issues impacting youth, families, seniors, and more. Our housing team, which we're both a part of, represents clients across Hennepin County in housing proceedings, including eviction defense, emergency tenant remedies actions, and rent escrow actions. Our housing discrimination law project is a part of our housing team, and through that project, we also provide advice and representation to people experiencing housing discrimination. To be eligible for services through legal aid, we use federal poverty guidelines to determine eligibility for services. In our housing practice, our services are income-based, but some of our services are available regardless of income. For example, our seniors unit for people ages 60 and over is eligible regardless of income, as well as our disability law center, which is a separate division of our office that serves individuals with disabilities in primarily employment or education or other disability benefits issues. So we'll start with the broad overview of some of the key laws relating to disability rights and housing. And the two that we'll talk about most are the Fair Housing Act, a federal law, as well as the Minnesota Human Rights Act. Next slide. So the Federal Fair Housing Act prohibits an owner, landlord, or an agent from discriminating in the sale or rental of housing based on the handicap, and I use that term simply because it's in the law. I know it's an antiquated term. We don't often use or prefer to use now, but that's how the law states it. So because of handicap of that, the buyer or renter, a person residing or intending to reside in that dwelling, or any person associated with that buyer or renter. So by that kind of three-part definition, it expands the protections for disability-related freedom from discrimination for disability to anyone in the household, whether it's the primary leaseholder, a child in the home, or even any person associated with them. And similarly, further in the Fair Housing Act, discrimination is prohibited in the terms, conditions, or privileges of a rental of a dwelling. And so we'll talk a bit about how these types of discrimination can show up in a few slides here. In addition, Minnesota has its own form of similar protections as the Fair Housing Act under the Minnesota Human Rights Act. And this law prohibits an owner, landlord, or agent from refusing to sell, lease, or deny housing to any person or group because of a long list of protected classes, one of which is disability. The Fair Housing Act and the Minnesota Human Rights Act define disability similarly, but there are some slight differences. So looking at the Fair Housing Act, it's more fewer words, but can be kind of open to interpretation. It's quite broad to capture any physical or mental impairment which substantially limits one or more of a person's major life activities. And then the MHRA has a little more detail in its definition of disability, describing the particular impairments that come into place there. So as I mentioned, some of the ways that discrimination shows up in terms of disability discrimination may not be as outright as you might expect or that you would think of. It often doesn't come in the form of a landlord saying, "I won't rent to you because of your disability." Instead, it often looks like some more hidden forms of discrimination that result in unfair results for tenants with disabilities. So, for example, before the tenancy, a landlord might impose an overly burdensome application process for someone who has a disability or raises a disability when they're looking for housing. They might refuse to follow up with someone on their application or make an unjustified delay, or discouraging them from applying to certain properties, like steering people with disabilities only toward a certain building that they own rather than another one, or just ignoring phone calls or emails and claiming that they don't have a unit available when they really do. Similarly, during the tenancy, there are other subtle forms of discrimination that we often see. The first two are with reference to the reasonable accommodation process that Courtney will talk about in some more detail. But we also see discrimination in the form of eviction cases and retaliation based on disability. Landlords may also give lease violations for a tenant that are pretextual, so citing a tenant with a disability more often for small lease infractions, for example, than other tenants. And then even situations of harassment or stalking could rise to the level of discrimination depending on the circumstances. And then after the tenancy, what we would often see is a landlord giving bad references regarding a tenant, excessive charges or withholding a deposit, or even just continuing to harass the person. So if any of those things are done because of disability, those would be prohibited discrimination under the Fair Housing Act or the Minnesota Human Rights Act. All right, I'm gonna turn it over to Courtney to talk more about accommodation.
Hi. Just a note on the last slide, another big area that I see a lot is kind of the issue of hidden disabilities. So a lot of times, a lot of disabilities aren't necessarily obvious or what people can kind of classify as hidden. And sometimes tenants will get well, you don't look disabled, and so we're not going to do that. And so that's a prohibited form of discrimination as well. So watch out for that. Now we'll talk about reasonable accommodations and modifications. Go ahead. So the two are very similar, with just a few key differences. So they're both changes in rules, policies, practices, or services, when that accommodation is necessary to afford the tenant equal access, to use and enjoy the dwelling. That definition holds for both accommodations and modifications. The key difference, with modifications and accommodations is the level that they rise to. Modifications are going to be some sort of change to the structure, or maybe a little bit more serious than an accommodation would be. Examples of modifications might be installing a grab bar or a stair lift or something like that. Something that really requires changes. Tenants cannot be required to pay for reasonable accommodations. Requiring a tenant to pay for any level of a reasonable accommodation is considered discrimination. However, tenants are usually responsible for modifications. Sometimes landlords can be held responsible for that, but for the most part, tenants can be asked to pay for those modifications. For reasonable accommodations, there is a way to make a request. There's no magic words needed. Sometimes, people get caught up on the fact that the tenant didn't actually say a reasonable accommodation. That's not necessary. So the tenant just has to follow the elements on the right. So make sure that it's, the request is linked to a disability related need. It's necessary to afford equal access and it's reasonable. As long as they fulfill those three elements, they've made a reasonable accommodation request. And additionally, anyone really can make an RA request for a tenant, including the tenant themselves, a social worker, a family member, anyone. So it doesn't have to be the tenant themselves. I would really encourage landlords to be very careful in listening to tenants and making sure that they're catching things that could be reasonable accommodation requests that aren't necessarily labeled as such. Housing providers do have duties in regard to reasonable accommodations. A lot of these slides just talk about accommodations, but it applies to modifications as well. So landlords can ask for verification of a disability or for more information about the connection between the disability and the requested need, but not necessarily details about the disability. So sometimes landlords will ask for a provider letter to just give a little bit more information about why it's needed, but they can't ask you about details of your disability. So that's a very fine line that landlords have a duty to walk. And then they also have to analyze every situation and every request on a case by case basis. So they can't, for example, say like, no service animals allowed. We're not going to do it. That's not permissible. Every request that comes in has to be looked at individually. There are certain circumstances in which a landlord can deny an accommodation or modification, and that's if the accommodation would present an undue administrative or financial burden. Say, you're asking them to put an elevator in a building that doesn't have one. That would likely be considered unreasonable, or if it's a fundamental alteration of the business practices, or if it poses a direct threat to health and safety, that cannot be eliminated or reduced through the accommodation. Landlords also have a duty to engage in the interactive process. So say your accommodation isn't possible. For example, a tenant might request to move to the first floor because they live on the fourth floor and they suffered an injury and can now no longer walk upstairs. There's no first floor units available in this building, so it's not possible. A landlord can't necessarily just say no and let it be at that. They have to engage in the process and really have a conversation with the tenant about if there's anything else that can be done. Maybe they can move them to a different building on the first floor that the landlord owns. Maybe they can put them on the wait list. Maybe there's an opening coming up, something like that. They have to engage in that process. Tenants don't have to accept alternatives to their requests. So if, landlord suggests something, a landlord or a tenant doesn't necessarily have to accept it. And it's not a stop to the interactive process. It's an ongoing conversation. And then finally, if a landlord fails to respond to a reasonable accommodation request, so say a tenant makes a request and the landlord just never gets back to them, that is considered a denial and can be a basis for a fair housing claim.
I thought we might pause there and see if there's any questions on those first couple topics before we move on. Oh, you're muted.
Yeah, we've got two questions before we move on. So the first question is, what is a reasonable time frame for a landlord to respond to an accommodation request?
That's a great question. I think it, in some sense, depends on the circumstances. If it relates to something fairly urgent, like I've had a situation where a client's elevator wasn't working and they couldn't leave their fourth floor unit without an accommodation. And in a case like that, you would expect a response rather quickly, if like one business day, if not sooner. But depending on the circumstances, something could be longer. I think the best practice is to at least acknowledge the request initially, even if there would be some time needed on the landlord's part to review and consider the accommodation, by first acknowledging it and saying, we'll be considering this, or here are some questions we have. That begins the interactive process, and just make sure it's an open communication. Is there anything I'm missing on that?
No, I would say just try to wait no more than a few weeks. I think once we're past the 2 to 3 week mark, it starts to become an unnecessarily delayed process. And like Julia said, it's case by case, but try to respond as quickly as you can.
All right, next question. Can a landlord require the tenant or provider to use the landlord's specific form for asking for an emotional support animal?
No. So if the tenant provides necessary documentation under the law, then that's a reasonable accommodation request and it should be honored. A lot of times, if there's information on the form that you would like to be provided, you can ask for that. But requiring someone to use a specific form is not a requirement you can necessarily stand on.
Next question. Can a landlord require tenants to have to pay move or transfer fees if there's an accommodation, right? So like in your scenario, if they had to move from the fourth to the first floor, can they require a transfer fee for that?
It's again a kind of a case by case basis. My inclination is to say no and err on the side of caution on that. That can very quickly be seen as paying for the reasonable accommodation. There might be some circumstances where that's not true, but again, I think most of the time that would be considered paying for the reasonable accommodation, which is not permissible.
I would say if a different unit is rented at a different monthly rent, proposing an alternative lease would be something that might be deemed reasonable, depending on the original lease term. They might ask them to consider a new lease at a different unit instead.
All right, next question. Is it necessary to have the reasonable accommodation in the lease? So I think what they're asking, like, do you need to modify the lease itself and have that sort of codified in there?
No, not typically. We often draft reasonable accommodation settlements that might be a separate document that the lease kind of supplements the lease, but it doesn't have to be in the lease itself.
And it doesn't have to be written. We always advise that, but reasonable accommodations can be both requested and granted orally.
All right, next question. Are there any required forms a tenant has to supply instead of using a landlord specific form for an RA or an RM?
If you want to just go back a few slides to the part about this, the next one. elements of an request. I would just make sure that whatever document you provide or supporting statements from a doctor, for example, would cover those three elements to explain why the thing you're asking for is linked to your disability related need, why it's necessary to give you equal access, and why it is possible. So those are the main elements I would include in whatever letter or supporting documents you have, but otherwise there's no specific format.
There's no like state forms, but if someone says, you know, I need a handicap parking space because I am paralyzed and I can't walk, you know, that's enough to meet the elements.
Does Homeline have template RA letters on your template list?
I don't believe we do.
I think the Law Help MN website has a good fact sheet on reasonable accommodations, and it might have some sample language there as a guide.
All right, we've got two more left, and assuming no more pop up here. So I've had this issue in the past, but what is the best way to approach a landlord who's attempting to avoid the conversation on an accommodation? For example, in my situation, this was about getting an emotional support animal. Both roommates had an individual ESA letter from their respective providers, and then I'm assuming like the landlord just wasn't responding to any
Mhm.
attempt to give the letter to them.
We'll talk about enforcement a little bit later, but in that situation, so if you're getting ghosted or if they're not responding, then that can be a time when you call an attorney.
Yeah, and
Alright,
I think it was mentioned before, but failure to respond can itself be a form of discrimination. So we'll share more about that when we talk about enforcement options.
okay. And then last one here, if anyone has any questions, we will catch you at the end here. But any tips for dealing with a situation in which a tenant made a verbal reasonable accommodation request to a property manager, and they don't respond and later say they never got it?
That happens a lot. My best advice is to always document things. So if you're the tenant, you know, send a follow-up email to property management if you're able to write them a note. And if you're the property manager, also send a follow-up email. So as best you can, try to document things and when they happened, who you talked to, what time. It's not required, but it is really helpful to get things in writing.
Yeah, and even if it's a one-sided letter, kind of like what Courtney's saying, just email them saying, we had this conversation on this date and I asked you about this accommodation, just to kind of make a paper trail.
All right, we got one more. And I'm gonna draw a line here until we get to the next stopping point. This tenant uses a wheelchair and they're not automatic paddles on the front entrance. The landlord gave them a fob. It was told to use the parking garage, but they have to, you know, sort of like avoid cars coming and going. Is there anything they can do about this situation?
Yeah, that's come up a few times. I think there is some argument probably in that case that the landlord's solution is unreasonable for the tenant and puts them in more danger. And that as a result, there should be another option. So that is a situation where I would suggest that that person reach out to an attorney for some more follow-up advice on that.
And there was a recent case that MMLA handled where the landlord was ultimately required to install a door that would open for a tenant with disabilities. So it's not out of the question to ask for something like that.
Okay, and with that, we've cleared the Q&A queue. I think this is where we were at in the slides, right?
Yes.
Okay, perfect. All right, again, if anyone has any questions, keep dropping them in the Q&A, and we'll answer as we go along. But with that, Julia, back to you.
Okay. A large portion of the cases that we handle at Legal Aid are evictions, defending people from eviction from their home. And so we wanted to also talk about when reasonable accommodations can come up in the context of eviction defense. There are many cases that suggest reasonable accommodations can be asserted as a defense to eviction. In Minnesota, there are two Court of Appeals decisions that seem to go kind of on the opposite direction of each other. Shuett was an older case that clearly demonstrates reasonable accommodation as a defense to eviction. But then in 2011, the Kleiman Realty case kind of questioned that defense. And so we do assert the reasonable accommodation defense in eviction cases, and courts will consider it, at least in our in Hennepin County where we practice. They're familiar with seeing that. But it is something that hasn't been firmly established by the Minnesota Supreme Court at this point. There is one 11th Circuit case, the Hunt case, that talks about an RA as a defense. And then in 2020, our office handled an accommodation defense that went to the Minnesota Court of Appeals, and the court didn't resolve the dispute between Shuett and Kleinman, but essentially acknowledged that it would evaluate the defense in that case. So just a note that it's not firmly settled law, but from our perspective, tenants can raise accommodations in evictions. And the common scenarios where these might come up include, first and foremost, most often we see these related to breaches of lease. So an example would be like a disability that contributed to a mental health challenge and a dispute with a neighbor. So oftentimes that's the result of something where a person may have had an escalation of their symptoms, or maybe their medication was off for some reason. And if they're able to obtain the needed therapies or resume medication, those symptoms would go away. And so then we often raise the accommodation to ask for a plan to change and rescind the eviction. Another situation is where someone's ability to pay rent is directly tied to their receipt of Social Security disability income. That often comes like at a certain date per month, and if that date falls after the due date for typical rent, it can sometimes result in late fees piling up. And so we see that on occasion. And then another situation we've seen a few times is a tenant whose physical disability or other mobility impairments are keeping them from maintaining housekeeping or other matters that alert the landlord's attention and push them towards an eviction filing. And the solutions that we look at in those kind of cases include primarily sort of plans to ensure that whatever is the alleged breach either won't recur in the future or are less likely to occur. So regarding like a neighbor dispute, the tenant could propose a plan to remain lease compliant and in control of their mental health disabilities through ongoing therapy and medication maintenance, for example. In cases like that, we also try to involve healthcare providers or other support people in the tenant's life to make sure that they can help facilitate lease compliance where possible. For a situation with the late fees, like I was talking about, we would ask the landlord to waive those late fees and agree as an accommodation to accept the rent on the date of disability payments coming in. And then for maintenance, home maintenance issues, if a tenant can put together a plan to maintain their home with support services or other caregivers in their life, that's often a way to resolve those cases. And then we will talk a bit more about pet fees down the road, but if a pet fee is part of like a non-payment of rent case, we can ask that those be waived if it's tied to a service animal or an emotional support animal. If you are a tenant facing eviction or you're representing a tenant, we have some best practices for negotiating that kind of agreement. The first one is to make sure the agreement doesn't set the client or the renter up for failure. So although we want to be able to assure lease compliance, we don't want to overpromise something that's not achievable for the tenant. For example, I was negotiating an agreement following a neighbor dispute, and the landlord was trying to argue that the tenant would have no verbal outbursts toward a neighbor. And for that person's particular disability, it was almost impossible to promise no verbal outbursts because it was a direct symptom of her condition. So instead we narrowed it in on what the client could promise of no physical altercations with a neighbor. And so that's just an example where you want to make sure you're not promising something that will be very hard for the tenant to maintain. With the accommodations in place, the tenant does have to remain otherwise compliant with their lease. The agreement should have an opportunity to give the tenant notice of any alleged non-compliance and an opportunity to contest those allegations. So we wouldn't want to put someone in a situation where the landlord could run to court and say the tenant violated the agreement just based on the landlord's version of the facts. We would want the tenant to have an opportunity to dispute what the landlord claimed had happened. The agreement shouldn't waive future rights to request an accommodation. So if it's a new scenario, a tenant would always retain the right to assert another accommodation. But we just would want to make sure that nothing is in the agreement to imply that this will be your last chance or this is the last accommodation. There's kind of a shorthand. We sometimes call these last chance agreements. And I always tell clients, it may be the last chance as to this set of facts, but if something new happens in the future, you can always assert a reasonable accommodation. So I will just caution that the reasonableness of a request may change the more requests that you make. So just a note on that. And then last, if it is a filed eviction, you would want to make sure you ask for the caption to be changed, a reference that the landlord would agree to be like neutral or to not reference the conduct tied to disability, and also expungement of the case. Any questions about the eviction defense category?
Yeah, we've got 3 questions we can work through here. One going back to RAs. So is a landlord required to pay for the reasonable accommodation of support services to help the tenant clean or maintain the leased premises?
No, and I think the specific exception there that the landlord would point to is that it's a fundamental alteration of their business practices to pay out of pocket for something like that. So if the accommodation is about the landlord's staff making changes to its own practices, they have to cover those costs that they might incur. But if it's a fundamental change to their business practice, then no, they wouldn't have to pay that. There's some guidance from the Department of Justice and HUD that talks about common examples, and one that they give is a tenant who had asked for help to take out the trash and basically said that that would be a fundamental alteration of the landlord's business practice, and so no, they don't have to bear that burden.
All right, next question. Is the Public Housing Authority exempt from any of the things we've talked about so far?
No, definitively not.
All right, we love a good bright line.
And I think there may even be more protections under the Federal Rehabilitation Act, which also applies to public entities. So even more so, they're subject to these laws.
All right, and then the last question we have outstanding right now. Do you have any information about how you can request information from the city, state, etc., for my uninhabitable living situation?
Are you looking for someone to if you're looking for someone to affirm that it's uninhabitable, you can always call the city inspector's office, and sometimes that can kickstart repairs being made or sanctions, kind of things like that, to hopefully get your conditions back up to habitable. There's also a website that you can go to see if there's been any complaints about the property.
And depending on where you're from, calling your local legal aid office to see if they have capacity to help investigate the issue, that might be another way to approach it.
Yeah, I would say, just to kind of hop in here, this is a good opportunity to plug Homeline. This is a situation where we'd probably need a little more information to sort of properly steer you. feel free to give us a call or email us, and we'd be happy to help you out with your issue. All right, one more came in. Does the answer to the support services question we did a few questions ago change if the landlord offers limited services for a fee, for example, housekeeping services?
It can. So, courts will never want to make a landlord a service provider, but if a landlord is already a service provider and that's part of their, the fundamental practices, then the way that they do those and kind of the timeline that those services are provided can definitely be part of a reasonable accommodation request.
All right, and that clears out our Q&A for now. Looks like we can move on to ESAs and service animals.
One more quick note. I love to add notes after it's over, but Julia kind of alluded to the fact of future discrimination and kind of reasonable accommodation. So a lot of times in settlement agreements, it might be asked that the tenant waives any future action, or discrimination allegation about this circumstance. You cannot waive future discrimination. So that might waive any claims for what's currently happening, but if there was another instance of discrimination in the future, you still have all of your rights under the law. Just want to make sure that that's clear. Okay, service and emotional support animals. So service and emotional support animals, we call them ESAs for shorthand. They are treated very similarly. They are different and they are defined differently. Service animals are different than ESAs, but again, the law treats them very similarly, especially in housing. So under Minnesota state law, tenants can request reasonable accommodations to have service or ESAs. No pet policies do not apply to these animals, and landlords also cannot charge any pet fees or deposits for them. That is akin to asking someone to pay for a reasonable accommodation. So if there's, if you're applying to an apartment and it says no pets, you can still make a request to have your service animal as a reasonable accommodation. These animals do not have to be registered, but a landlord can request documentation related to the animal, like vaccination records. That's actually very common. So the animal can still be required to follow all, local and state laws, like being vaccinated, maybe being neutered or spayed if that's part of the law. And landlords can require that the animal follows those laws. Landlords also have to individually assess each animal individually. So again, must treat each reasonable accommodation on a case-by-case basis. And breed bans do not apply to service and ESA. So like it says, a pit bull ban wouldn't necessarily apply to a service animal. If a landlord wants to deny a reasonable accommodation request because of the breed of an animal, they have to show that that particular animal, rather than the propensity of the breed, so that particular animal is shown to be dangerous. And then just lastly, so it's important to remember with service and ESAs that reasonable still applies. So, you're going to have a lot more luck getting a dog or a cat as a service animal rather than a peacock. So exotic animals and exotic pet rules still apply. And then we'll talk about some enforcement options if you are experiencing discrimination, or if a client of yours is experiencing discrimination. Go ahead. There are several options in Minnesota on how to make a complaint, and several ways that you can use the process. So all of these can be done pro se, so all of these can be done by tenants, or all of them can be done with the assistance of an attorney, by an attorney. You can first of all go the administrative route, so that's filing a complaint with the Department of Housing and Urban Development. You can go on their website to submit a complaint via a web form is the only way to do that now, I think. You can also file a state complaint with the Minnesota Department of Human Rights. That's the MDHR is what we call that. And you can do that either by phone or online. And then you can also file a complaint with your local civil rights division. So for example, Minneapolis has the Minneapolis Civil Rights Division, and they handle discrimination complaints and do investigations there as well. Those are beneficial a lot of times because they have investigators assigned to the case, and there's a big focus on settling the problem. So if you kind of are just really focused on asserting your rights and getting things settled, those might be the best route. You can also always assert, just do a legal action, whether in state or federal court. It's important to remember the statute of limitations. So under the Fair Housing Act and federal court, the statute of limitations is 2 years from the incident of discrimination. And under the Minnesota Human Rights Act, you have 1 year from the incident of discrimination to file a claim. And that's all we have, and we will take more questions.
All right, so we've got 3 questions outstanding right now. So going back to ESAs, can landlords require any charges at all for ESAs? So for example, some do like the DNA swab for like animal waste, or require like bite insurance. Can they do anything like that, or is it a pure blanket ban on fees?
So if it's a fee to have the animal, no. If it's maybe some fees that everyone else has to comply with, so like a DNA test. I think that's a little bit of an area that hasn't ever been litigated, so it's unclear. I would certainly include it in a reasonable accommodation request for a tenant. It could be seen as paying for the accommodation, but it could also be seen as a reasonable expense. I'll also say that for ESAs and service animals, the tenant is responsible for any damage done by that animal. So for example, say the tenant moves out and the, cat has scratched up the walls. The tenant is responsible to pay for the damage that that animal did.
Okay, next question. This was submitted during the ESA portion, so I'm assuming it's for ESAs only, but maybe generally. Does any of this change for shelters?
That's a great question, and we've seen it come up a few times. So shelters can be included under the Fair Housing Act, as the definition of a dwelling is quite broad. I think there has been case law in some jurisdictions. I don't know that Minnesota has like a settled decision on it, but we would argue most of the time that a shelter falls under the definition of a dwelling under the Fair Housing Act. There might be some limited exceptions, like depending on the type of shelter. Shelters in Minnesota aren't regulated very consistently. So if a shelter has like applies under one of the exceptions under the FHA, then that wouldn't, but in most cases, yes. Do you agree?
Yeah.
One note too, we sometimes get questions about like dorms and things like that, and those also fall under the Fair Housing Act.
All right, I'm gonna exercise moderator's privilege to insert a personal question here that I have. So looking back at landlords can't require registration. So my question is, like, I know in St. Paul, I have to register my dogs. Is registration about just registering with the landlord, or is it like any sort of registration at all? Because my thought's always been like, for city registration, like, a dog is a dog or a cat is a cat.
Yeah, so registration means like registering that animal as like a service animal. So there's a separate database of ESAs and service animals, but if it's a local ordinance and it needs to be registered with the city, I think that would fall under that exception.
Okay. All right. Can you speak to the reasonableness of a tenant requesting 2 or 3 ESAs for just one person? When does that have to be approved, or when can it be denied? Right. So is like there any sort of bright line there?
A single person can have multiple ESAs or service animals. Typically each animal has to be connected to the need, and I'll say it should be probably a different need. So for example, someone can have 2 service animals that both provide different functions for that person, and that is reasonable. There is a limit. I'm not going to tell you a hard one because with a lot of this, it depends. But yes, one person can definitely have more than one ESA, and service animal is considered reasonable.
All right, so next question, is a landlord responsible to another tenant if a service animal or ESA bites them? Perhaps the argument would be that the landlord shouldn't have allowed the, service animal or ESA because the animal doesn't really qualify as such.
Oh. I don't think that the argument that the landlord shouldn't have allowed it, because it's not an ESA. I mean, presumably at that point, right, the tenant has done their due diligence and provided the documentation that they need to, and so it can be established that it's necessary. I don't know if I know the answer to that.
Yeah, I think that's kind of outside of our expertise because it's more like a tort action against the landlord. I don't know that it would necessarily fall under landlord tenant principles.
Yeah, I would be surprised if a landlord were liable for that specific circumstance, but I'm not gonna say no.
And I think a landlord might be justified in revisiting the accommodation request with the
Mhm.
tenant after an incident like that. To, make a change at that point.
All right, it looks like we have kind of a follow-up question here. Give me a sec to kind of read through it. Okay, I'm gonna read it. Looks like they may have more information here. So it says, I want to make sure I word this correctly. Can a reasonable accommodation be a request that goes against the quote standard that is set by the assumption that all tenants are the same? If this doesn't make sense, I would have to give an example to make it make sense. Hope that makes sense.
Um. Yes, that is, to me, the purpose of a reasonable accommodation is that, this person needs a specific kind of carve out almost. So it's any change in rules, practices, or procedures. So a reasonable accommodation request can ask that a landlord changes their policies that apply to everyone as well. I don't know if there is an example, but
And I think it's important, one of the elements that we had talked about is the tenant needs to be able to have equal enjoyment of the housing. So for some people, that might require different treatment to enjoy the housing equally. Happy to follow up if there's more. Yes.
Okay, it's from anonymous, but it looks like we nailed it on that one.
Right.
All right, and that is our cue for now. Stick around for a few minutes in case any more pop up, if that works for you too.
Yes, happy to. Since we have some time, we could share about a couple of recent success stories and examples, just to give a sense of how these accommodations come up in practice. Would that be helpful?
Yeah, I think so.
So we recently had a client who had a voucher for a 1-bedroom unit, but because of a medical need, she had a lot of physical medical equipment that ended up taking a lot of her apartment. And so she asked the housing authority for a voucher size extension to get a second bedroom where she could store things like a walker, canes, and even like a medical bed, and things like that. The request was originally denied, and then the attorney working the case negotiated further with the housing authority and ultimately was able to get an extension or an expansion of the voucher size so that her voucher was then for 2 bedrooms. So that's something that we are often involved with, is accommodations with a housing authority or Minneapolis Public Housing, to make sure that residents with disabilities are able to enjoy their housing equally. Do you have any other recent good stories?
Oh, I'm sure I do. I will say that a lot of personal accommodations can seem very small, or like basic. So we've also had cases where someone requested to put a Ring camera up on the outside of their door because they were disabled and couldn't get to the door, and painful for them to move to answer every door, and that can be a reasonable accommodation. So don't think that something is too small. These reasonable accommodations are important, and they affect tenants' day-to-day well-being and lives. And it's important to know your rights, and it's important as providers to listen to tenants and really try to figure out a solution.
All right, so we got, looks like 5 questions here.
Wow.
We were here yakking.
All right, so first one, are you aware of any ESA provisions that allow the animal, for example, a large dog, to be off leash? And I'm assuming they're talking about like common areas, sort of like in an apartment building, things like that.
Generally no. They still need to be on leash and be well behaved. And not attack others. I can't necessarily think of something that would stop that as being a requirement.
Yeah, I think all of the elements and defenses of a reasonable accommodation apply to ESAs. So what a landlord might be able to say in that situation is this could pose a direct threat to neighbors if this
Mhm.
dog is off leash, and so that direct threat exception could apply there. But I think the question kind of suggested whether there's a rule about it. There's not like a very detailed regulatory guidance around ESAs. A lot of it is case by case, and we look at case law for examples.
And in that situation, there's usually a city ordinance that is a leash law. So they would have to follow that.
All right, next one, not really a question, more of a comment, but just thank you for the very helpful information, and thank you for the thanks.
You are welcome.
All right, can you talk about the expansions of disability definitions that kicked in August 1st, 2025?
Is this talking about Minneapolis ordinance?
It doesn't say, that's my assumption.
So something that kicked in August 1st was an expansion of Minneapolis ordinances regarding discrimination. And it added height and weight as protected classes under Minneapolis civil rights ordinance. And so landlords cannot discriminate against a person based on their height or weight. I don't think it was implied that those are part of disability, but just another protected class. So if I'm missing something, I'm happy to learn.
All right. Oh, we got a follow-up from him. All right. I'm just gonna read it off. So Minneapolis expanded fair housing protections effective August 1st of this year. Beginning August 1st, Minneapolis will implement amendments to its civil rights ordinance, expanding the list of protected classes and broadening the scope of anti-discrimination rules for housing providers. These changes were adopted under Ordinance 2024-00563 and will significantly impact the multifamily housing market.
Yes.
Yes.
Mhm. Yeah, those additional protected classes were height, weight, whether someone is housed or unhoused, and then justice impacted status, so someone's criminal background. Thank you for the citation to the questioner.
If you're interested in that, this Minneapolis Civil Rights actually has a very helpful little web sheet on it if you visit their website.
All right, next question, and I can take this one. Can the slideshow be sent out and emailed to everyone after this training? Yes, I've got sort of a master list of everyone that signed up, and I can blast that out. Or if you'd like, I can just drop my email address in the chat and just send me an email, and I can forward you a copy. So I'm gonna do that right now.
With the disclaimer, this is not intended to be legal advice for your particular situation. If you want legal advice, please contact an attorney.
Yes. All right, going back to the landlord liability for a tenant biting, tenant's ESA biting another tenant, with potential landlord liability to another tenant who is bit or similar. Isn't the landlord in a position where they may be inclined to grant a reasonable exception for a service animal or ESA because they're afraid of violating the law? but also then exposed to liability for allowing the animal.
I think at that point, if that were to happen, like Julia had mentioned, there's that carve out to reasonable accommodations if there's a direct threat. There's also, I don't know if this rule is the 1 bite rule in Minnesota a thing.
I don't know.
Well, so there's some tort rules around dog bites too. So I think that's a complicated scenario. I don't see that happening very often. Usually service animals are pretty well behaved. There could also be, different ways that the tenants themselves can kind of work around it. Like if you're taking the dog out, only go out the back door, and then this tenant only goes out the front door, or something like that, just so they never cross paths. Or transferring, one tenant to a different building or different side if they're willing to do that. So,
I guess I would try to think about an ESA less as a pet and more as a medical need.
mhm.
So if we were to say this tenant had an accommodation and they use a wheelchair and that wheelchair rode over someone's foot, like in that case, perhaps there's some liability that the landlord might face, but that's completely separate from that tenant's request and need for the accommodation. So I think it's important to like separate the two.
And it's not a reason to preemptively deny the RA. I mean, again, every animal needs to be looked at individually, and if there's a history there, maybe you have reason not to grant the accommodation. But it's not permissible to deny a reasonable accommodation request because an animal might bite someone down the line. That's discrimination.
All right, so next question, I'm gonna go back to, let's see, am I on the right slide here? Yeah, filing complaints. We got a question about sort of the differences between filing with HUD versus Minnesota DHR or like St. Paul or Minneapolis, like sort of how do those processes differ?
Usually not very much. They kind of differ on time sometimes. It doesn't apply to disability, but so for example, like the Minnesota department, if you were to want to bring a discrimination claim on sexual orientation or gender identity, those are protected classes that are specifically listed in the Minnesota Human Rights Act. So you might want to file with the Minnesota Department of Human Rights. Your local civil rights commissions might move a little quicker, and especially like, again, if there's the height weight thing, you'll want to file in Minneapolis because that only applies in Minneapolis. But if it's disability in general, it kind of just depends on the process that's easier to use, and they'll all take a long time. Just be prepared for that. They move slowly and they investigate slowly, but it's kind of dealer's choice in the end.
All right, going back to the example of the tenant who had all the medical devices so much that they needed a second bedroom. Do you know what rent they paid? Did they pay the 2-bedroom rate or the 1-bedroom rate in that example?
So this was a voucher request. So their voucher from the Public Housing Authority was expanded to a 2-bedroom voucher to cover the 2-bedroom. So the tenant's portion would still be dependent on Section 8 rules as far as what they owe. But the rent was a 2-bedroom rent.
Okay. So we got another question, or really more of a comment about the change to the Minneapolis City Ordinance for protected classes. So now includes conditions that are either episodic or in remission, or that substantially limit one or more major life activities when active. And the questioner was asking if you had any specifics on sort of what qualifies as episodic or in remission.
Oh. That's a good question. Let's see. I guess I would consider something like autoimmune conditions that can flare up or, subside and then get worse. I think it just wants to try to get at conditions that aren't like constantly the same symptoms, but that come up periodically.
I think
Yeah.
the important thing is substantially limit one or more major life activities. So if it and that's a definition that holds true for disability under the ADA. So if it's like affecting your life the majority of the time substantially, someone with an autoimmune disease might feel fine today, but not tomorrow. And so they're not disabled today and disabled tomorrow.
Yeah, I was thinking of earlier in the presentation, we had the example of someone who had like occasional outburst, right? Like they have sort of episodes,
Mhm.
once every week or so. And to me, that's different than someone who's paralyzed and is, paralyzed all the time, right?
Yeah.
Mhm.
All right, and that is Q&A for now.
I noticed one comment in the chat that many landlords do have breed restrictions, like on pit bulls and Rottweilers. So I don't dispute that that's true, even though it is illegal. So just a example of many leases contain illegal provisions. So keep an eye out and call Homeline if you have questions.
Yeah, one question on that that I've sort of run into, and I'm not sure I have a great answer, is so the Minnesota DHR has some guidance on ESAs. And so the way they break it down is if you have an ESA or a support animal before you sign a lease, they can't impose breed restrictions on you. But let's say 6 months into a year-long lease, your provider or whatever says you should get a support animal. At that point, it's reasonable for you to follow existing breed restrictions. Does that match sort of your expertise on the issue?
That is on their website. I have seen that. Their caveat was unless you can demonstrate that that particular breed is needed. I think that that's probably going to be considered reasonable. Again, unless you can demonstrate that you like specifically need a pit bull. I don't know how one would do that. But yeah, at that point, you might want to follow breed restrictions if you can.
But I mean, if you did happen to have a doctor's note or an explanation of
Yeah.
why a particular breed or dog was necessary, I think they would have to consider that.
Yeah.
It can't just be in all cases, no.
Right.
All right. Any experience or thoughts on accommodations for mold? For example, if a tenant has allergies or asthma or some autoimmune issue that makes them particularly susceptible to mold.
Yeah, I think a lot of habitability issues like mold or other allergens can be approached both as a repair issue and an accommodation at the same time, or an alternative. I think it would be reasonable to propose to a landlord that they need to respond to a repair condition promptly, or maybe transfer you to a different unit if you're experiencing a disability related symptom because of the repair issue. Like anything, you would want something, it would be best evidence if you had like a doctor's letter to support the connection between the two, because that would demonstrate that it's necessary.
All right. So that is, landlord perspective. All right, landlord here. Just as a comment, it's sometimes difficult to acquire insurance if there's a pit bull. And I'm assuming they mean like in the building.
Yeah, I don't know how insurance works, but that is a downfall of kind of, I think, where practicality meets the law, but it's still impermissible under the law.
Yeah, and we encounter a lot of landlord attorneys who are very well versed in reasonable accommodation law and kind of see the gamut of issues. So if you want to consult an attorney on a particular situation, that seems like a reasonable one to bring to an attorney.
Maybe we can change insurance.
All right, so I've got 2:35 right now. I'm gonna say we give 2 more minutes for Q&A, and then if not, we'll give people some of their day back. See what comes in here.
I should have clarified at the beginning in terms of Mid-Minnesota Legal Aid's services. Our office does provide advice or representation on fair housing issues through through our grants that we have. And so if you do have questions about this, Homeline is a resource, but also Legal Aid would be a resource if you're within our Minneapolis service area within Hennepin County or Anoka County. The the website for legal aid is mylegalaid.org. In response to the chat question about a consultation. If you go to our website, there should be a link there to start an intake online or the phone number to call.
All right, we got 2 more questions here. All right, so can this, it looks like, can this tenant run something by, I guess, either us, either MMLA or Homeline, to see if it's a reasonable request prior to requesting? Definitely yes for Homeline. I'm not sure on your end.
Yes, yeah, we could advise on something like that.
And are there accommodations to ask regarding noise sensitivities due to disability, and neighbor noise or harassment?
Yeah, I would probably need more information, but there could be a request probably made with some parameters. We can't necessarily ask to control others, but I've had circumstances too where in answer to that, like a neighbor making noise, that person is asked to move to a different unit farther away. So that could be a fix for the kind of issue and part of the reasonable accommodation process. So it's possible. It might not be exactly what you want, but sometimes we can get creative.
We've had cases similar with neighbor issues regarding smoking. If someone is like particularly susceptible to smoke as a disability, and then a neighbor has a lot of excessive smoking. And I think what happened there was, one neighbor moved units to resolve the issue. But that's one of those where approaching the landlord to try to discuss it in the interactive process to see what's available might be the best way to resolve the problem.
All right, and then going back, looks like they had a follow-up. Can they ask to get carpet or install soundproofing as sort of remediation there?
Again, potentially it depends. Do the lawyer answer? It depends. A lot of it depends on the disability, the connection to the need, and how reasonable it is. So I can't give you hard answers to a lot of these because reasonable accommodations and disability discrimination is very case by case, in fact specific. So if you're wondering, I would reach out to Homeline or your legal aid and ask to talk to someone.
All right, and with that, unless you guys have anything else, I think I'm going to call it here.
No, thank you.
Yeah, thank you everyone who showed up for a lively discussion. And again, thank you to Julia and Courtney for their time today. Really appreciate it.
Thank you. All right, happy to do it. Thank you.